Senator McDonald. Excuse, here we go. Now we'll all be in the same meeting. Good morning. It's Senate Natural Resources Menu, continuing our work. We're turning to a bill introduction, S-254, an act relating to including rechargeable batteries and battery containing products under the state battery stewardship program. I'll say very briefly that as in other years, I've stayed in communication with people in the solid waste world who are dealing with the various kinds of solid waste that we have to deal with, which is always evolving. And got a request to bring us up to date because there are rechargeable batteries, for instance, out there that weren't already accommodated in existing policies. So I'm happy to help us keep a program that's up to date, and that's the reason for me participating in this. With that, really, let's invite Mr. O'Grady to join us at the table and walk us through 254. Good morning, thank you for coming.
Do you want it on the screen or not?
Sure, that way if someone's watching the YouTube version, they'll be able to see what we're looking at. Thank you.
Get out of my poultry slaughter. Paragraphs to the
I miss those days. There was a year in my life where all painted food bills for my teacher report. The uninspected chickens and raw milk.
What terrible thing did you do to earn that?
I signed up for it. It was part of expanding opportunities and value added agriculture. For people who want to be closer to the source.
That was a great pitch. I'm not going to introduce those bills.
isn't there for some reason. It says Zoom link, but it's not there.
But it's not there.
But I feel you push the boundaries further.
Here you go.
But
As a proud chicken owner. Sorry about that.
it looks normal. It looks like a normal Zoom. And I put them.
It doesn't go anywhere.
There's no link.
Well, if we get stuck, we'll just do it with people.
Okay, well, we can start on paper, I suppose.
No, there's no, I don't know.
Just for context, there is an existing extended producer responsibility program in the state for manufacturers of primary batteries. I think you all know what the extended producer responsibility programs are, EPR. The manufacturer is required to set up and administer a program based on a plan that you require them to have for the collection, usually free of cost, to customers, so they can drop off the no longer useful product at no cost to the consumer at a convenient function. So
I can just check in, no cost to the consumer at the moment you drop it off, but you may have been asked to pay as part of running the program, right? Like, I'm thinking of paint. Do we not call that really
I said usually at no cost to the
Oh, okay,
consumer.
all right. Well, no, I just want to make sure that we consider the paint program.
That is a program where the cost of the program is built in based on a I won't call it small, but there's an assessment on each container of paint. But this program does not have that. As to whether or not the cost of any of these programs is incorporated into the cost of the consumer product, likely at some point it is. But it's also likely spread across either the entire manufacturer's product line or regionally.
So if, for instance, like there's not batteries sold.
Not get the Vermont cost battery, right, or the Vermont cost EV, et cetera. So this program was enacted in 2013, 2014. And at that time, there was already an organization that was dealing with rechargeable batteries, or allegedly dealing with rechargeable batteries. And also at that time, there were concerns that products that were being sold with a battery in it shouldn't be part of this program because the batteries at that time were allegedly difficult to remove from the product. In the past 10 years, the Rechargeable Battery Stewardship Organization, I'll let somebody else characterize how they're doing, but the number of rechargeable batteries, the amount that are being sold, the scope and scale of their presence in the market has increased exponentially. And the people are returning those rechargeable batteries to the primary battery collection points, because that's what's they know and that's what's convenient to them. In addition, I'm sure you all know, you probably purchased many products over the past 10 years, where it's pretty easy to remove these batteries from products. It's not difficult. The product is usually designed to make it easy to remove the battery. Consequently, what this bill does is it amends the battery stewardship program to not only be about primary batteries, but to be about primary batteries, which we're no longer calling primary battery, rechargeable batteries, and battery containing products.
Can you remind us, please, what primary batteries?
Well, why don't we just dive into the definitions first, and we'll get to primary battery quickly. The first definition is on page 2, line 1. This is the battery containing product, which will now be part of the program. It's an electronic product that contains a primary or rechargeable battery that are easily removable or is packaged with rechargeable or primary batteries. It does not include an electronic product regulated under the e-waste program. So if you're in e-waste already, and like one of the things I think of is keyboards, right? Some of those remote keyboards have a battery in them, but they're part of the e-waste program already. So moving on from there, the next big change is damaged and defective lithium batteries. There are batteries that have been damaged or defective for safety reasons, or that has a potential of producing a dangerous evolution of heat fire, short circuit. So these are going to be addressed in this program in a slightly separate way from the other batteries because of their risk. And so you should know that they are defined in statute. So then you come to the definition of primary battery. I said earlier that we're not going to call primary batteries anymore. That's not, we're not calling this program the primary battery program. We're calling it the battery program, but there's still primary batteries that are part of that program. So a primary battery needs a non-rechargeable battery weighing currently is 2 kilograms, but it's being proposed to change to 4.4 pounds or less, and including alkaline, and then proposed for inclusion silver oxide, zinc, air, carbon, zinc, and lithium metal batteries. And then beginning on January 1, 2026, it would include a non-rechargeable battery weighing more than 4.4 pounds, but not more than 25 pounds. Currently, what is excluded from the definition of primary battery are those used for industrial business for maintenance services or non-personal use. or a battery that is sold in a computer monitor, computer peripheral, printer, television device containing cathode ray tube. Remember, they're now going to be covered in e-waste, they're already going.
And that was, brought thanks to chapter 166.
Yes. Then what is currently not part of the program is a battery that is not easily removable or is not intended to be removed. So now, remember, I talked about how many of the products that have batteries in them, they've been designed to easily remove those batteries when you buy that product. So you're still excluding those that are not easily removable, because there will be some where you just can't not access that battery. But you are striking that language where it's not intended to be removed from a consumer product. If it's still easily removable, even if the manufacturer didn't intend it to be removed, it's going to be covered by the program.
Mr. Chairman.
So,
Are there any requirements for manufacturers of products to make the batteries more easily removable?
Not that I'm aware of. I think there are actually some requirements for certain products such as toys where you're not supposed to make the battery easily removable. But I don't know if the inverse is true. And then last was currently excluded are batteries that are basically defined as medical devices by the FFDCA. But I know that I've gone and looked at hearing aids at the pharmacy and seen that there are batteries that are easily removable, and there are other medical devices like that. So the batteries that would be excluded in medical devices are those that are contained within a medical device that is not designed and marketed for sale or resale at retail locations, because all those devices effectively have easily removable batteries. They wouldn't be sold in those locations if they did not. So that's the change to a primary battery. A significant number of, or significant categories that used to be exempt are not, and or you're effectively nuancing what those exceptions would be.
Can I have a quick question on top of for line 2 and 3? Silver oxide, zinc air, and carbon zinc. Why are these guys showing up now? Is it just new?
I think that they are just more prevalent
Okay.
now, and they're coming into the program anyway.
Yeah.
People are dropping them off anyway.
Yeah.
So why not?
I just haven't even heard of that zinc air before.
You get to the definition of a battery producer, not a primary battery producer, just a battery producer. It's a person, one of the following with regard to a battery or a battery containing product. It's a person who manufactures that battery or battery containing product and who sells or offers for sale a battery or battery containing product in the state. If that doesn't apply, you'll see subdivision B line 4, that is a person who licensed a trademark or brand for which the battery or battery containing product is sold or offered for sale in the state. And then if A or B don't apply, then it's the person who imports the battery or battery containing product into the state. Then you see the definition of a battery stewardship organization. It's basically the same as any stewardship organization. Same stewardship plan. Rechargeable battery, beginning on page 5 and going on to page 6. One of the things here that is changing is the weight. It's weighing not more than 25 pounds and having a watt hour rating of not more than 2,000 watt hours. So the large ones you are not bringing into the program, but you are increasing the scope of the ones that were currently defined. So before it was weighing less than 11 pounds, it's now weighing not more than 25 pounds.
Thank you, Mr. Chair. Would an example be like so we have like electric lawn mowers now? I'm not sure how much an electric lawnmower battery weighs, but I'm assuming a car battery is much more than 11 pounds, but maybe like a smaller electric powered,
Yeah, I think that's a
it's like that
good
kind of.
example, yeah.
Okay. Thank you.
It does not mean a battery that is not easily removable from a battery containing product, so consistent with the definition of a primary battery. It's not a battery that contains electrolyte as a free liquid. It's not a battery that includes lead acid technology that is sealed and contains no liquid electrolyte and weighs not more than 11 pounds. And then it is not a battery recalled by the producer for safety reasons, and it is not a battery contained within a medical device, provided that it is not designed and marketed for sale or resale displayed at a retail location.
So the exclusion, that starts on line 12 there, containing electrolyte, but that's, we're talking about old lead acid batteries, we're just not calling, those are not rechargeable, and you're calling, okay?
Okay, so then you can go to really page 9. Chapter 2 of the program. Sale of primary batteries, rechargeable batteries, and battery containing products. So currently, the primary battery manufacturer has to do all of this. All of this is already applicable to the primary battery manufacturer, except you're bringing in a couple more primary batteries into the program, like the medical devices that are sold at retail, etc. Now there's dates here. Right now it says beginning January 1, 2016. Later on in the bill, in an implementation section, you're going to see that there's another date, and it's 2026 for the expansion of the program. So just to bring in the rechargeables and the battery adder. So it's 2 years away before it kicks in for the expansion. You don't see that in this language here because we now have a new directive that we're not supposed to include dates in the substance of the statute, which was always one of my
And Pete,
yeah, no, it was always one of my things that I did all the time. And now I have to train myself not to do it.
I see.
And
Well, it's one of the things I always ask you. Let's put dates in.
how solid is that rule? It's not entirely solid, but you know, it's a gel,
Is it
a
a
hard gel.
free
So,
liquid in the acid?
Okay, science teacher, watch.
So- right now, the primary battery is prohibited from sale unless the manufacturer participating in a stewardship organization and implementing a stewardship plan. In 2026, when the program expands, it will be a manufacturer of a primary battery, rechargeable battery containing product. That product will be prohibited from sale unless they're in a stewardship organization and implementing a stewardship plan. So that's the key sale prohibition on page 9, line 2.
Quick question on the PROs for batteries or EPO. Are there multiple, do you know if there are multiple entities that have formed organizations, or pretty much everyone's one big happy? Well,
Right now, I think there are 2.
two.
And one's rechargeable oriented and one's. And they want one.
Okay.
All right. So I think. On page 10. You'll see a producer of a rechargeable battery or battery containing product 2 after January 1, 2026 seeks to sell, offer for sale, or offer for promotional purposes. Rechargeable battery or battery containing product not previously sold in the state, notifies the secretary prior to selling or offering it for sale. So they were selling before January 1, 2026. They're gonna have to be part of the program beginning January 2026. After January 1, 2026, they have to notify and become part of the program in order to sell. Another key part of this section is page 10, line 15 through 17, the small manufacturer exemption is being struck. It's probably just not applicable in this industry.
Artisan.
Right, bad artists and batteries, right, unless you're like the potato manufacturer, so.
Other students skills.
Yeah, exactly.
Students will have to register.
Oh, yeah.
So moving on, page 10, line 18, you're moving into 7583. These are the requirements for the stewardship organization, the manufacturers, the producers. Now of primary, rechargeable, and battery containing products have to form a stewardship organization. There are qualifications for that stewardship organization. They are very consistent with the qualifications in other EPR programs. They have to assume the responsibilities of all their producers. They cannot have barriers to participation from other producers. They have to have a website that lists all of their producers and their brands. They have to register with the secretary and provide a similar list of information when they register with the secretary, including a list of their producers and brands. We're now on page 12. Contact information for a person with the organization, a description of how they meet or allow for participation, a contact person to allow people who want to join to contact. And then basically what they have to do for a stewardship organization. Then you get to the plan, and will be now the plan for primary batteries, rechargeable batteries, or battery containing products. And it is similar to many of your other EPR plans. First, the plan has to list all of its participating producers and brands. And then it has to provide for free collection. What are called covered entities, and covered entities is effectively any person. And the producers shall not refuse the collection of a covered battery based on the brand or concern of the battery. They have to provide for convenience. This is always the criteria that raises some interest among the rural, the legislators representing rural communities. Except for damage to defective lithium and batteries and lithium ion batteries, which we'll talk about in a minute. Each battery stewardship plan shall allow all retailers, all municipalities, certified solid waste facilities, and certified salvage yards that meet requirements specified in the plan to opt in. So they are not mandated collection facilities, they can opt to be part of the plan. And the plan must provide at a minimum, not fewer than 2 collection facilities in each state that provide for collection throughout the year. Now that's the one that the rural communities are like, well, I have to still drive 45 minutes to get to my collection facility. So, but how do you make it more convenient for me? And I expect you'll probably, that usually comes from the house. But I expect that you'll hear something about them. And then page 14, that for collection of damaged and defective lithium batteries and lithium ion batteries. So we're like, why are these different? Because they explode, right? Right. So you don't want them being collected at the retail place and being in a little canister that could be a fire risk. So they're different, and they allow any certified solid waste facility to collect them. And provided that the facility can meet the safety requirements as outlined in the stewardship plan. And the plan for these will include how the program will provide packaging consistent with the U.S. Department of Transportation hazardous materials regulations and the necessary forms and instructions for safe transportation. And unless otherwise provided by the secretary, the plan shall provide throughout the year, not fewer than 2 collection facilities at a minimum in each county in the state for the collection of damaged and defective lithium batteries and lithium-ion batteries.
So how will a regular old consumer know that the battery's damaged?
Whether a battery's damaged, well, it doesn't have to be damaged, right? It's not working effectively. I think that's,
Like full recharge?
right. The plan needs to include the method of disposition of all batteries collected and how they are managed. They have to put into the plan the roles and responsibilities of everyone in the collection system, the transporters, the collection sites, recycling sites. They need to provide education and outreach to the public about where collection sites are, what is collectible, what is not collectible, etc. Page 16, slightly different from other EPR programs. Line 7 is this plan has to have a reimbursement component, because we're going to see in a minute that the battery program has a different reimbursement subchapter. It has to have a performance goal and a collection rate. The rate shall include a collection rate performance goal for primary batteries and rechargeable batteries subject to the plan. The collection rate includes the estimated total weight of primary batteries and rechargeable batteries that would be sold or offered for sale in the state by the producer participating in the plan. There has to be safety training now, including handling damaged and defective lithium batteries and lithium-ion batteries. And then an important part for some of the advocates, especially those that are going to be operating as collection facilities, is that it has to provide a description of how municipalities and certified solid waste management facilities acting as battery collection facilities shall be fairly compensated for labor and material costs associated with their activities. So implementation, it's not going to be required to be implemented, the plan, until 6 months after the date of final decision of the secretary to approve. And then you can move on to page 18. There's an annual report from the stewardship organization. It includes what you would intuitively think the weight of batteries collected by chemistry, by producer, the percentage of batteries collected in the prior calendar year that are from producers who are not participating, the collection rate achieved in the prior calendar year, the location for all collection points, the educational materials, you're on page 19, the manner in which the batteries were managed, any material change to the plan that is being proposed, and then the cost of implementation. And then after 5 years, this was after 5 years of the original implementation, there was an audit. You can read this language as being just a one-time audit that was satisfied. I don't know if you want to renew that audit requirement or be clear that that audit requirement is renewed when the program expands in 2026.
Page 19, line 5, any material change, just. I'm having a hard time separating material change, like, are we literally talking about like chemistry change, or are we talking about like substantial change?
It's the plan, it's the change to the plan.
Right, so substantial change.
So you'll see later on, actually, anytime that the manufacturer, the producer wants to change how their plan is implementing, they have to submit it to A&R. It's that.
Okay,
Anything that has to go through that approval process is 7586.
okay,
And that approval process is subject to public participation under A&R's type 3 procedures.
Okay, thank you.
Excuse me, you're checking to make sure it's that kind of material change,
Right.
not like chemistry.
Yeah, exactly. I was just wondering what the use of material was there, but I think I'm clear. Thanks.
Um, page 20. These are A and R's responsibilities, again, very consistent with other EPR programs. They have to determine whether the plan complies with the requirements set out in statute. They have to approve the plan and notify the applicant, et cetera. They have to approve amendments, which we were just talking about, page 2916. Any changes to the plan that shall be approved by the secretary. There has to be public review. It says shall proceed in accordance with chapter 170 of this title. That's the standard procedures that A&R uses. It's type 3 under 10 BSA 7714. The agency has to have a website that includes a copy of the battery stewardship plan. They do have a website that complies with this. Has all the names on it. You have to click down a couple of levels, but you get to it. Now they're going to have to include all the rechargeable battery producers and battery containing product producers and their brands. And then the term of the battery stewardship plan shall not exceed 5 years, provided that a producer or organization remains in compliance. So if they're not in compliance, A&R has the ability to say, hey, you now only have a 2-year plan or a 3-year plan, because we need to come back to you more often. There's retailer obligations, there's the prohibition, except as set forth in subsection D, which is an inventory exception. No retailer shall sell or offer for sale a battery on or after January 1, 2026. Unless the producer of the battery is implementing an approved battery stewardship plan. Remember, we're going to talk about implementation later on. Then there's the inventory exception. Retailer shall not be responsible for an unlawful sale of a primary battery, rechargeable, or battery containing product if they purchase the primary battery weighing 4.4 pounds or less prior to January 1, 2016 and sell it before January 1, 2017. Or they purchase the battery weighing more than 4.4 pounds prior to January 1, 2026 and sell it on or before January 1, 2027. Page 23, line 12. Subchapter 3 was really a duplicative requirement for registration of a rechargeable battery stewardship organization. Now that they are part of the full stewardship organization, where that's the intent, you don't need to register rechargeable. I referenced earlier that the battery EPR program has a slightly
Tim,
Yeah.
Martinez.
Sorry, I'm just going back with this, so the inventory exception. So basically, if you. The part that's being added is if you sold it before 2027, but the program goes into effect in 2026. So just
It
a,
doesn't expand until 2026.
right,
But if that retailer had bought that battery that weighed more than 4.4, why does it need to weigh more? Because before 2026, anything that was less 4.4 or less was already part of this program, right? And they couldn't sell unless the producer was registered and implementing a plan. After 2026, they get a year. Maybe they bought it. They get a year to sell the inventory that they bought prior to 2026.
okay, thank you, that helps. Sorry, thank you.
Page 24. I referenced earlier that the battery EPR program it's got an unusual node to it, and that is that it has a subchapter based on reimbursement, because back when this was first enacted, they weren't getting along real well, and they didn't trust each other to like actually reimburse each other for what they collected. So there's this whole reimbursement process Apparently they're getting along better now, but they still want the reimbursement language for those that aren't participating. And there are numerous battery manufacturers across the globe that wind up, their products wind up here. So they want to have this reimbursement process continue in order to basically have an enforcement tool for those producers that are not participating in the program. I don't know if you want me to go through it. Basically, it's just a procedural process where they submit a request from the one that's allegedly not participating. They can only put in this reimbursement request once they've reached their collection rate. So you don't get to like non-perform and then say, oh, you gotta pay me for the battery. You have to perform and meet your collection rate, and then you can start to see reimbursement.
In the, same way.
Who is the alleged producer who's not doing this?
So
Is it like a big, you don't need, if is it a big company that I would know? Like, is it?
I think, and I don't want to characterize any place, or there are products that are imported into the United States that have batteries in them by not readily recognizable US for multinational manufacturers. Sometimes they are independent, but often they're within the product and they are easily removable. And the person that importing them is not participating in the program. So
So it's not like Milwaukee, it's somehow.
I you know,
It's.
you might want to talk to the battery. You know, whoever's running the organization right now, I should say, and to see if they can give you more concrete examples.
Thank you.
Imagine if you were importing electronics and they all had replaceable, easily replace rechargeable stuff. And they might be coming from all over the world, but they're not necessarily part of our ERF.
Think of your TV remotes. You know, you pull that out and it has language on there that it's not Mandarin. I don't know what it is, right? So page 26, there's the whole reimbursement process. And then on page 27, you get to confidentiality. These are some of just the general provisions that are basically in all EPR programs. So what the manufacturers or producers submit is generally information protected under the Uniform Trade Secrets Act, their share of the market, etc. Provided that the secretary may publish information confidential in a summary or aggregated form, and then the secretary may require a report to be submitted that omits any trade secret information so that it can be readily available for public inspection and review. One thing we need to be clear about: the total weight of batteries collected under a battery stewardship plan is not confidential business information. So, and then there's the antitrust provision that's in all EPR programs, because you are basically requiring manufacturers, producers to work together and develop a program. It looks like collusion. So you basically say that they are exempt from antitrust prosecution for that participation, provided that on page 29 that exclusion from antitrust does not apply to any agreement between them affecting the price of batteries, or any agreement restricting the geographic area in which the primary batteries or rechargeable batteries are sold. Then you come to the fee. The fee for the organization is $15,000 paid annually. A&R to cover the costs of A&R's review, approval, and administration of the program. Those fees go into the Environmental Permanent Fund. The Environmental Permanent Fund is used to pay the cost of the program, including staff. Page 30.
I do, so. There were, or are two organizations right now, that. The a battery company may need to pay fees into. And with the merging of those, I assume that a lot of those. The companies that are paying to the two organizations now are largely overlapping. So this would, I assume, either be a cost benefit to them or us not collecting as much money.
I think that's a correct assumption. I don't know how it will play out in the end as to cost effectiveness for them. Because you have an expansion of the program, it might be more expensive to collect certain types of battery containing product, things like that.
And that's on top of. That they, something that they might have to pay in addition to is $15,000.
Right.
Yeah.
Right, so EPR programs, they pay for the cost of the program amongst the producers.
Mhm.
It's usually a cost that they agree on how the costs are allocated. You know, generally, we say it's based on market share, but they can agree to whatever they want for their allocation of costs.
Mm.
But they pay for the program.
Thank you.
Then you get page 30, line 9, section 2, landfill disposal requirements. You are now going to ban rechargeable batteries and primary batteries and any other battery added by the secretary by rule. Right now, it's nickel cadmium batteries, and then there's another one that's lead acid batteries. So they will be banned from the landfill. And then on section 3, A&R does an assessment of the opportunities, challenges, and feasibility of establishing mandatory end-of-life management programs for the following:
Oh, nice.
batteries in hybrid and electric vehicles, battery energy storage systems like your Tesla Powerback, batteries that are not easily removable from the products that they power. Assessment includes a summary of the work in progress other states have made in establishing end-of-life program for these battery types, and policy recommendations on whether end-of-life management programs are necessary for the battery types listed. And you get that. And then you come to the implementation section, requirements for sale. Under 7582 applies to batteries weighing less than 4.4 pounds beginning January 1, 2016. And those over 4.4 and not but less than 25, that's January 1, 2026. The requirement for the organization to register with A&R currently applies for those primary batteries. It will apply for the new ones beginning March 1, 2025. The requirement for a battery producer to submit their plan for the new ones is June 1, 2025. The requirement that the battery producer annually report that is going to be for the new ones March 1, 2027, and then thereafter. When the retail sale obligation takes effect for the new ones January 1, 2026.
When we did the similar build out for the Bottomville, we had a provision in there that if no organization steps up with a regional plan, you know, then A&R would write the rule, but we don't have any sort of fallback provision, and that's just because there's no concern that we already have two plans, and this is gonna be sort of just business as usual, advising we don't need an A&R fallback position.
So the EPR for beverage containers is a little different because you mandated that they all participate in the one. And so the concern was that they weren't gonna be able to work together, cooperate enough to get to that. Whereas here, they have opportunity to do multiple organizations. So the hope is that they do one, but there is no mandate that they all participate in the same thing. So even if some can't agree, the ones that can agree are going to submit a plan for patient
Which you can't agree, you're not gonna be able to chat.
cancer.
So be motivating.
Right, that, that's a little bit more easily to digest because you're not talking about pretty much every beverage in the state, right? Because that's what the expansion would have reached except for dairy and dairy like, so it's a little different when you're dealing with food than,
Right,
you know,
many different products, novel products every week. Okay, any further questions on this one before we go to the next bill?
My apologies for this, question. This feels kind of fundamental. Because there's two organizations now, one for primary batteries and one for chargeable batteries. And this just combines. Why combine them?
because people are bringing the rechargeables to the primary one and the rechargeable ones are taking up more of the market. And for efficiency, you really just want one program where they're all working together.
Okay, mayor comment.
Yes, please.
Jen Holiday with the Chicken Solid Waste District. It's important for you to understand that the rechargeable battery program is a complete voluntary program. And so the manufacturers are not on the hook for anything. They have been doing it for many years. But because of the significant increase in rechargeable batteries and products that are out there and the consumers, products that consumers purchase, that it's important to them to have something that provides this level playing field. And because the collection programs already exist for primary batteries as well, and they're getting mixed by consumers because consumers aren't gonna tell the difference. They wanna work together. They're already getting primary batteries in their program, primary batteries manufacturers getting chargeables in their program. They support working together in one stewardship organization, but they do need this legislation to get everybody on board.
Thank you, that's very helpful. And I do have one more question.
Sure.
Which I'm not sure who this is better for. I'm familiar with a kind of battery that I would call a nickel metal hydride, and I didn't see that in the expansion. Like silver oxide, zinc air, carbon zinc, lithium.
It's not under the rechargeable battery precaution.
So.
That's okay, I mean, it's something that we can be added, I don't know.
We might want to have to check with the battery manufacturers, but there's less and less of that type of thing.
There.
But there's still a.
Yes,
The rechargeable, yeah.
they're rechargeable, yeah.
So it's old.
I ran into some the other day and had to look it up. So,
So you have a voltaic or galvanic cell.
I'll look up what that means too.
So the citizen on Saturday morning. Going to the transfer station. Right now, there'll be a place to dispose the batteries.
Right.
And that, those things will change. As soon as you just make the battery. And someone at the transfer station. Separates.
They have to separate, and that is becoming more and more of an issue. It's very significant in terms of time. So they will now be reimbursed for their time. The product associated with that.
And every transfer, and, because the state is, or the manufacturers.
Correct.
Then, okay.
Great, thank you, everyone, so more to do, but, and, timing wise, I'm, hopeful that this bill seems, both important and pretty, tightly contained, so hoping that roughly 3 or 4 weeks out from now, we'll be able to come back to this and move it, pretty promptly through and bring it forward. All right, so that brings us to another bill introduction, S-258. And act relating to the management of fish and wildlife. I'll. With the sake of complete transparency, I just wanted to let people know where it comes from. And what I anticipate happening with it, and that is. I asked Mr. Ray to draft based on what we learned in the last couple of years, actually working on fish and wildlife rules. And in essence, I talked to Tucker Anderson and Village Council, asked them how many boards we have in the state of Vermont. There are approximately 300. And of the 300, only 2 boards have the opportunity to write rules, the NRB. Not correct?
Not correct.
All right, and also good finger here. I thought I got the Anthea and I was pointing to just one place, so.
So Tucker wrote, responded to your email and he listed out about maybe 20 other boards.
Okay, so I have to follow up on the other boards. When I was looking in law, there was a section that we changed, right, where it said NRB and. So my misunderstanding, I'm glad we're doing the walk through the water. Because we were changing just one place where it gave them rulemaking authority, I didn't realize there were other places in law where a board got rulemaking.
So liquor and lottery, cannabis control board, victims compensation board, Truth and Reconciliation Commission, the licensing boards at OPR, which are many, so each of them has their own rulemaking. And then Green Mountain Care Board, the Education Board. There are others like the Bader Safety Review Board. And the State Labor Relations Board, Parole Board, Enhanced 911 Board, Current Use Advisory Board. And there are others that are listed.
Okay, thank you. So want to check in with you and up to speed on the exact linkage, but
But could I just interject? It's like, they get their rulemaking authority, you give it to them. Right? And it's something you can take away at any time. It's your authority, basically. You're the ultimate policy and lawmaking body, and you have the ability to delegate it. Within the bounds of delegation.
thank you. And I think, you know what. So what I observed as a member of Elkhart going in was a very awkward situation where when the Fish and Wildlife Board proposed the rule in response to the bills we had 2 years ago, we reached the commissioner and the council for Department of Fish and Wildlife presented it. And then when, Elkhart would say, how about this, that, or the other thing, they would have to go back to the board, ask, have a discussion and get the board's response, and then they were carrying it again back to Elkhart. And it seemed like a very it didn't seem like a highly functional way of addressing the rulemaking. The commissioner was playing it, sort of the role that a normal commissioner doing normal rulemaking would do, but in fact had a check-in with the Fish and Wildlife Board every time we looked for a change or had a. So this just, to me, it was the concept is regularize it and, take the authority that there is the right rules around, fishing hunting. And give them to the commissioner because, the commissioner already has that authority elsewhere. Other than for the fishing and hunting rules, why not bring everything back into department and see to me like that's sort of a simplification and good governance. So that's, one of the reasons for bringing the board back into the department. The other thing is that, well, I think we're all conscious of the fact that there are other Vermonters who are looking at game and non-game fish and wildlife and would, I think, like to participate in the discussions around their management. So the reconstituted board has a broader set of criteria for being eligible and selected to join the board. And the bill, it doesn't, I want to make sure that anyone who listens, we don't eliminate the Fish and Wildlife Board. It is continued and reconstituted. I've heard some concerns that we're politicizing it by changing the appointment process. Actually, we're in a political environment, so I don't know what that claim actually means. Currently, the governor does all the appointing. This says, let's broaden the appointing powers to have the speaker, 3 committees, and the governor contribute 1/3. So feels like a more open and transparent and less particularly subject to sort of partisanship because there's a much broader participation in how folks get named. And that's probably, and then one other thing we had, we enacted 2 years ago, a moratorium on hunting coyotes with hounds. My own sense based on testimony in here, in Elkhart, talking to citizens, is that remains problematic area because of lack of control of animals. And there are many people who are disturbed by hounds coming through their property, and they say, well, property rights are front and center, chapter 1, article 1, Vermont Constitution. Why do I have to be subjected to having this happen? I'd like to get property right. The way we were working with thread the needle was to say, we're not banning the practice of hunting with hounds, but you do need to maintain control so that those trespasses don't happen. So far, we've not seen a method to ensure that happens. So if the bill proposes the use of hounds in that way. So that's really a reformulation of the board, making them advisory. Commissioner takes on those duties, a broader process for bringing people on the board. That's it. There's no, people said, well, you're ending hunting, but there's no ending of hunting. It's just a range on practices like coyote.
Thank you, Mr. Chair. I know that this will be a topic that will have some response from our constituents. And I think the framing that you just provided us is very helpful. The point that I just want to underscore, especially for myself, and why I was a co-sponsor of this bill, is that it's not a policy change in what we are doing. There's no end change that I'm looking for the board to come up with by the reformation of it. Rather, it's having a group of people that more accurately reflect the users and the people impacted by the decisions of the board, rather than seeking like one policy outcome that, not the goal here, and I think we've had it asserted, is that this bill is meant to stack the deck in a certain way to have a very specific policy outcome. So I really appreciate you being clear that that's not the goal of the bill. The goal of the bill is to more accurately reflect the picture of who is who is participating in our natural spaces. So I just wanted to make sure that folks knew that there's no hidden long-term policy change that we are envisioning, at least in my own personal co-sponsorship.
Right, and there's provisions that we'll walk through that, seek to balance things, like in terms of what kind of background you have to participate. But the three naming parties, need to coordinate efforts in order to achieve some balance. There's also a provision that I did mention about, there's already law, that there's a management plan for non-game species, and I think we haven't paid much attention to that, so it asks the commissioner to revisit that and refresh the non-game plan. So it's, again, sort of like opening the lens up and looking at not just animals that are subject to consumption, but more broadly animals in the Vermont environment. So, enough intro, maybe more, if we can just go to a walk through Mr. O'Grady.
Well, I was gonna give an intro too.
Oh, good. I'm gonna be interested in your input.
Totally.
So I just want to give context, right? Because often people will say that the Fish and Wildlife for Vermont are constitutionally held in public trust. And I don't agree with that, because I don't think, like in other states, it does say that they're very natural or held in public trust by the state. In Vermont, it doesn't say that. It says that people have the right to hunt, to fish and fowl the lands of others that are not enclosed, subject to regulation by the General Assembly. So that debate about public trust arose in this body maybe about 10, 12 years ago, when there was a moose that was being fed donuts and beer within an enclosure in the Northeast Kingdom. And that person that owned that land said there was nothing that prevented that moose from being in his enclosure, and that it was his moose. And so the General Assembly sought to clarify, and they clarified it by establishing a policy in 10 VSA 4081, which says that the Fish and Wildlife of Vermont are held in trust by the state for the benefit of the citizens of Vermont and shall not be reduced to private ownership. And then directed that the Commissioner of Fish and Wildlife shall manage and regulate the Fish and Wildlife of Vermont in accordance with the requirements of the statute and the rules of the Fish and Wildlife. And the Fish and Wildlife Board have the authority to adopt rules to manage that's specified. But they had the authority to adopt rules for the regulation of fish and wild game and taking thereof, except as otherwise specifically provided by law. But you also need to realize that the Fish and Wildlife Department has authority that is different from just the management of fish and wildlife and the taking of fish and wildlife. For example, who gets to use a fish and wildlife access area? That's not about management of fish and wildlife and the taking. So the Commissioner of Fish and Wildlife adopts his or her own rules. So you have two sets of rules at the department, what are called the Commissioner's rules, what are called the Board's rules. And what this is doing is eliminating the Board's rules and making them a Commissioner's rules. And so the Commissioner is the rulemaking authority, not just for those things that are not related to fish and wildlife, but are related to fish and wildlife and the taking thereof. The board survives, but it survives in an advisory capacity, like most boards in the state are. As the chair was referencing earlier, there are hundreds of boards. Most boards are advisory. And this would turn the Fish and Wildlife Board from a regulatory board to an advisory board. So you'll see the first change is on page 1. This is 10 VSA 4041. This is the establishment of the Department of Fish and Wildlife. This is really just some technical language about the commissioner being appointed by the Secretary of A&R. And in addition to the powers and provided in the chapter, they shall have, the commissioner has all the powers that are set forth in Title III. And such additional duties that may be assigned by the commissioner. It's just basically framing that the commissioner is part of the agency, subject to the secretary's appointment and subject to authority that could be directed to the commissioner by the secretary. There is also in that same section, the establishment of the Fish and Wildlife Board, and the new language provides that they shall serve in an advisory capacity to the Department of Fish and Wildlife in the establishment of department policy and rules. You'll see that the board on page 2, line 11, the composition is being changed from 14 members to 12 members. So the chair referenced earlier, the current composition is 1 person from each county appointed by the governor with the advice and consent of the Senate. There would now be 4 persons appointed by the commissioner, 4 by the board, 4 by the speaker of the house, and 4 by the committee on committees. They still serve 6-year terms as they do now, but they will be staggered in their appointment so that their terms do not all expire in the same year, just as they are now. In order to be on the board, a person has to apply to one of the 3 appointing authorities. In considering the applications, you're on page 3, line 7, the appointing authority gives consideration to the geographic diversity of membership, the need for board members to have a history of involvement with and dedication to fish and wildlife, including a knowledge of fish and wildlife biology, ecology, and ethics. The need for the board to include members of the public representing both consumptive and non-consumptive uses. And then the appointing authorities are directed to coordinate their appointments to ensure the appropriate composition under subdivisions A through C. And then there is a definition of non-consumptive use. What does that mean? It's watching, photographing, listening to wildlife, and similar other activities without engaging in hunting, fishing, trapping, or any other extraction. Upon appointment, the members receive training from the Department of Wildlife Biology, coexistence with wildlife ethics, and the reduction of conflicts between humans and wildlife, and the impacts of climate change on humans and wildlife. So what happens when there is a rule? So upon filing of a proposed rule with the Secretary of State, which is the beginning of the Administrative Procedure Act. Previous 838 is when the Administrative Procedure Act starts. That's when you formally recognize that there's a rule that is going to be offered by an agency. And then after that, there's public participation. The agency has to respond to public comment and review. And then they submit with a final proposal with the Secretary of State and NELCAR. And then 45 days from there, or whatever time it takes NELCAR to review, then it's approved.
Jim Watson.
Thank you. How does this rulemaking process compare to typical rulemaking process?
It depends. So there is rulemaking like this. The one that I'm most familiar with is what used to be called the Pesticide Review Committee at the Agency of Agriculture. It's now called the Agricultural Innovation Board. The Secretary of Agriculture has rulemaking authority over pesticides, but before they can go to rulemaking, the Agricultural Innovation Board has to make a recommendation. Right? It has to make a recommendation. The Secretary doesn't need to honor it necessarily, but there has to be a recommendation from that board. And they are an advisory. And so they recommend to ag what to do. You are seeing something very similar here, except that usually at the agency that they don't even bring a rule forward until the AIB or Justice Review Committee has looked at it first. Here, the process is the department brings the rule forward to the Secretary of State and then gives it to the board for review. And then the board considers whether it's designed to maintain the best health, population viewing opportunities and utilization levels of the species. And whether or not it's adequately supported by investigation and research conducted by the department. And then if the board votes or determines that it should be revised, that the rule should be revised, they submit a written report to the department setting forth its recommended revisions within 60 days of receipt of the proposed rule. The department doesn't need to follow the recommendations, but they need to give a reason why they're not following the recommendations.
And it's the same before and now.
No, like now, the board made up of the 14 members, they vote on what a rule should be. And they propose that rule through the. It's supposed to be the board that is doing all of the procedural aspects of it, but the board staff is by statute is the department. So it gets a little convoluted. When the board is proposing the rule, the general counsel for the department is usually the one that's there. That is representing the board and what the rule does. But it's really the board's rule, it's not the department's rule. It's just that the general counsel is the staff to the board. As specified by statute. It can get a little confusing as to whose rule it is, but it is the board's rule.
Did they have notice and comment periods comparable to the APA?
So the board process is a little bit different because it is a public board. They have their own internal process for when they approve a rule and how they approve a rule. Generally, they need. I didn't refresh my recollection about their internal procedure, but generally they have to vote twice to approve a rule within the board and its internal procedure. And so that's different.
You know, if they have
But
to,
that's before the APA, you know, or could be during the APA, but as it was this past.
they have an obligation to take public comment and then respond in writing to it. And like, when we go through Elkhart, we looked to see if there was the process was followed for notice, comment, and response by the department.
Well, there's two public comment aspects to every meeting of the board is a public meeting, so under the open meeting law, everyone that there's supposed to be an opportunity for anyone there to participate. Then during rulemaking, the rulemaking entity has to put the rule out, the proposed rule out to receive public review and comment, and generally that includes a public meeting. The public meeting process, though, the agency, the rulemaking can establish a process for taking public participation, public input that doesn't allow for everyone to get up and speak. The best example of that some of you may remember is the Lake Shoreline Protection Commission, when there were hundreds of people at these meetings and you only had like 2 hours. And you basically said, we're not gonna take public comment tomorrow.
There was a sign-up sheet.
There was a sign-up sheet, but there was a limited sign-up sheet. And then anybody that didn't get on the sign-up sheet, they could fill out an index card and submit that. And legislative council had to collect all of those and put that into a document that was.
Turning a grade have to.
Right. And so that you can do that, and a rulemaking entity can do that. When you're dealing with such, volume, or you have vitriol in the public comment period, you can establish rules for the taking of input and public participation.
Right, so thanks,
So moving on. If the board recommends that the rule should be revised and the department doesn't follow that, they have to provide an explanation. And that explanation has to be submitted to LCAR. So what LCAR will get, just as they get the input from the committee chairs now, they'll get input from the board saying, hey, we requested a revision, and then the department will have to respond to that. And LCAR will receive.
I'm looking at the clock and I know that we have plenty to go left, I don't wanna rush them anyway.
I can move quickly. So the page 5, line 3 through 6, the whole appointment of the commissioner as the executive secretary of the board is no longer necessary. The policy provisions where you are giving the board authority to set policy, page 5, line 17 through 19, that's being changed. It's now going to be as the Department of Fish and Wildlife, including the department's rules on non-game management. On page 6, line 6, the commissioner shall commence rulemaking to develop that non-game wildlife plan not later than July 1, 2024, and shall complete rulemaking not later than September 1, 2025. And they will work to harmonize provisions of the Fish and Wildlife rules to realize the public interest in sound management of game and non-game species. Another thing to remember is that the Fish and Wildlife Board is the one that regulates deer management and migratory bird management and moose management. And they all have different processes currently right now. So the department will be taking over those processes and holding regional hearings, etc. To identify where and how many deer would be taken under any particular season. And that's the conforming changes on page 6 and 7. And that takes you to page 9, section 3. These are the fish and wildlife regulations. These are the rules that are authorized for the taking of fish and wild game. First major change, page 9, line 3, it's no longer the board adopting them, it's the department. Second major change is that they are going to require to be supported by the best science available through department and peer-reviewed research. Then you'll see conforming changes of board department for migratory game birds, or from board to department for the daily possession and limits of migratory game birds.
And I'm gonna interrupt, sorry, just flag, because I think it was really important that in terms of how we're managing, the addition of the provision about best science available to Department of Peer Review Research, that's 9 and 11. This is, again, management based on science and best management practice, not sentiment. Back to you, Mr. Brady.
I think you can go to page 11, section 4. This is just directing that the department has the rulemaking authority for the taking of fish instead of the board. And then section 5 is amending provision in Title 3. Title 3 is effectively where executive agencies and departments are created. You create almost every executive agency for departments. You created them, you give them the authority that they have, you can take it away. You can change what it is. You have the authority to direct who gets appointed and by whom to these boards or authorities, who's hired. That is your authority. And one of the things you're saying here is in 3 2803, is that the Fish and Wildlife Board no longer has regulatory authority at all. So that's page 11, line 19. They are just going to have the advisory capacity of all boards and commissions, and this is probably where that input that only the Fish and Wildlife Board and Natural Resources Board have regulatory authority. Probably the people that adopted the rulemaking for those other boards didn't amend the section,
Oh,
and so.
that's where I went astray. I should have asked more questions. Okay.
Page 12, section 6, there's conforming revisions. This is a authority for our office when we do our review of the statutes at the end of each legislative session. If you're not aware, our office reads every single line of text in the green books every summer to revise them. Make sure that everything is right. And one of the things we will do when we see the Fish and Wildlife Board reference, we'll change it to department if it's consistent with this.
So it's like the subtext.
It can't have any other substantive effect. It has, if the change somehow changes the substance, we can't make that change. And there are people in the building that don't let that, like secretary. So, and then there's a transition section, the Fish and Wildlife regulation promulgated by the board. Effective date of the act remain in effect, but they shall be implemented by the department until such time as they are repealed or amended. You should also know, little known fact, that the rules were first enacted in statute. And so that is why you can amend any of the Fish and Wildlife rules by statute, because they were first enacted by statute. And some of them are unchanged since 1961. So you have that authority. And then you come to page 13, line 5, section 8. This is the provision relating to the hunting of coyote. It would be a prohibition on the pursuit of coyote with 8 dogs, either for the purposes of training a dog or taking coyote. And that a person shall not take coyote by using bait. Used in the subsection, bait means any animal, vegetable, fruit, or mineral that are placed with the intention of attracting wildlife. But you need to know that yesterday litigation was initiated to challenge the board's rule on the hunting of coyote with dogs and the other objections. There is a provision in law, 1 VSA 214, that says pending suits are unaffected by legislation. So that means that any change to this will not affect that litigation unless the courts and the parties rely on this in their litigation. So the court might say, this is no longer relevant, it's no longer a rape case because the General Assembly has prohibited it. So I just want you to know that regardless of what you do, the courts continue on. And even when you have tried to tell the courts stop, they say, go back to your building.
Yeah,
Go next, 115.
we'll run this shop.
So be aware of that. I am really kind of uncertain about what to do about those existing rules. Dean and I have been talking about, like, if you pass this, do you include a provision that says those rules are null and void? You don't really need to, because when statute and rule conflict, the statute controls. But would that be something that the public?
Right, so just like a clarity for the public's benefit
Right.
addition. I would think it would always be helpful to round in the direction of clarity, so maybe if you could think about drafting language that
Yeah,
points out that that changed,
The bill does repeal the authority for that,
right?
which is section 9 sub A. And it repeals the moratorium because if there's no authority, the moratorium is irrelevant. So,
Do you think section 9 is clear enough?
yeah. It's whether or not that's clear to the public, well, I don't know, I see that.
Let's think about it, right? The other thing is that, also for my part to be clear, so when Elcar objected, they raised 4 very specific objections to the rule. Also, I acknowledged that there was a tremendous amount of work done by many people in order to write the rule, which was far broader than the 4 objections. And that was passed in, is the rule ballots and it's in force. And I just want to make sure that when we're talking about these changes that people understand how much has been approved and put into place. However, the 4 specific objections, Elcar was objecting on behalf of the General Assembly to 4 provisions and in order to bring clarity to it, I was planning to sit down with Mr. O'Grady and draft language that would be added to this bill that makes the legislature's position specific. So that there's not a question of intent anymore.
But remember, you enacted these rules and statute. So you can amend these rules by legislation. Now, if you want to amend those rules the way that Elcar messaged when they objected, you can do that. The General Assembly can do that.
So I'm just feeling that this is sort of following through on General Assembly, expressing the General Assembly's will as represented in the Elcon process. So just so that someone they well, why is there any new additional language? And it's because I'd like to see us make good on what Elcar pointed out. Issued a formal objection, certified objection to the Secretary of State. Any questions for Mr. O'Grady? And thank you for people for staying a little over, Mr. Senator McDonald.
Page 13. Line 7 and 8. No person shall take, shall pursue coyotes with dogs for, and it enumerates 2 reasons. Other reasons that one could pursue coyotes with dogs.
So the definition of take is very broad. It is not just the killing of the animal, it's the following, possessing, harassing. So I don't think you could engage in an activity with the pursuing coyotes with dogs that would not fall underneath that which should take.
Other than their having escaped from a chain gang or robbed a bank. The coyotes.
Still think if you're gonna pursue them with dogs, that would be taken.
Senator Watson, thank you. I guess I want to clarify that because line 7, at least line 7, 8 doesn't off page 13. That particular sentence doesn't call out taking, but you're saying that if you're pursuing a coyote, you're taking it.
You can pursue coyote either for the purposes of training or taking the coyote.
Okay, so, but I think what Senator McDonald's question is there any other reason that you could let a dog pursue a coyote?
Photograph.
Right. Could you say, well, so I guess one question would be, do you need to include the purpose there? Or is it sufficient to say no person shall pursue coyote with the aid of dogs?
Period.
You could say that. I It would be limiting, but I don't know what it would limit,
This is all that we can imagine is for those two purposes.
right? Right, so to be clear, Kate means to pursuing, shooting, hunting, killing, capturing, trapping, snaring, and netting fish, birds, and quadrupeds, and all lesser acts such as disturbing, carrying, worrying, wounding, or placing, setting, drawing, or using any net or device commonly used to take fish or wildlife animals, whether they result in the taking or not, and shall include every attempt to take and every act of assistance to every other person in taking or attempting to take fish or wild animals.
Okay.
Wait, is that from the bill or is that from,
The definition of take.
that's the definition? Always the definition.
Yeah. It's pretty consistent with the
Yeah.
definition of take
Yeah.
as well.
Sounds. Hard to imagine not being. Part of that definition, but I think any other questions for council?
Well, just something that may come up later, all people just think about for now. I've made the argument to constituents who don't like the bill. And they say that it's basically anti-hunting, and I made the argument, well. Our wildlife is game, but it's not just game, it's not only game, and that this. Would take a broader view. I heard from at least one constituent who had made a point that I found difficult to. But, which was that the way the bill has the new board appointed. We have 8 appointments in the legislature. And 4 commission. And he suggested why not, well, he was suggesting, also that they're going to 12 from 14 cuts 2 counties out. We don't know what they are, but he was suggesting, why not 7 and 7? And that is back up to 14, so you got all the counties represented. And then 7 and 7, which I don't see a need for, I don't think the legislature is anti-hunting, the bill is not anti-hunting. But there are people who don't trust us, and if they can be made feel more comfortable. I think actions speak louder than words. We're not anti-hunting, but there are people who are absolutely against it. So. Put them at peace.
Yeah. Okay, well, let's mull that over.
Yeah, just follow
I'm pretty comfortable with the idea that the representatives, 180 representatives are a broad base to bring ideas forward to the legislature. So the speaker and committee and committees will have a broad sensibility, if they do their work. Okay, thanks so much, Mr. Grady. And I think we'll return to this bill when we finish our